complaint against the lawyers of 17 of his family members this morning. He is alleging that David Smith and Wesley Hayes misled the court by submitting in affidavits that ailing former President Nelson Mandela is in a vegetative state, thereby warranting an urgent hearing of a matter concerning the exhumation of the elderly statesman's 3 children. To explain this issue further, we are now on the line to Chief Mandla Mandela's lawyer, Gary Jansen. A very good morning to you, Mr. Jansen, and thank you very much for speaking to us. If you could just start by explaining to us the nature of the complaint and with whom it's been lodged.
Well, first of all, there's obviously a lawyer involved who's the instructing attorney. So we have a body called the Law Society which looks at these complaints, and obviously the advocate belongs to the Eastern Cape Bar Council. So those are the 2 bodies which we've asked to lay a formal complaint. And it's based on the fact that it now appears that the lawyers, in order to get this matter to court on an urgent basis, had said that President Mandela was in a vegetative state, and they needed to accelerate his claim. Not his claim, or needed to accelerate the case. It now appears that those doctors' reports, which they had indicated in their affidavit they would present to court, was never ever presented. It appears that the doctors never had any intention of giving such affidavits. So the falseness of the claims are serious. It also goes the background of the fact that from the start of the proceedings, my client, Chief Mandla Mandela, was denied an opportunity to go to court. You must recall that...
if I could just interrupt you before we get into that particular issue, just to clarify, you say there was no intention to submit such an affidavit. Now, to our understanding, there was a certificate that was drawn up. The original certificate, to our knowledge, that made those claims, according to reports, was not submitted. So are you saying that the certificate of urgency that is dated June 27 as submitted to the Eastern Cape High Court is the one that in fact made those allegations?
Correct. Look, to set out urgency, you have to allege it in the papers, but not only with regard to the certificate. If you look at the applicant's affidavit, which was submitted to court, she says in there that I will submit evidence from the doctors supporting my claim that the president was in a vegetative state and that they were considering all sorts of options. Now, those affidavits haven't been presented to the court, and it was based on that that was a certificate of urgency. Now, under oath, she said that they were going to submit these, and she said that they have these affidavits from the doctors, which is not true. And notwithstanding the fact, and that's why there's a further investigation, and we're looking at it this morning. Obviously, if you've lied under oath, that is a serious claim of perjury. So it's quite serious, and it's got serious repercussions to my client.
And the second complaint you say is that your client was denied the opportunity to respond in court.
Well, you must understand that he had found out in the newspaper, in newspaper reports on Friday, that this order had been obtained. Now, firstly, Mr. Hayes, the attorney for the applicant, knows me because the 2 of us are working together. He's in the opposite. He's acting for the chief's wife in a divorce, and he knows that I'm the attorney of record. He could have phoned me and said, "Listen, we're bringing this urgent order," but there was no intention. Secondly, once I found out about it over the weekend, I had written to him inviting him to send me any papers with regard to the case. And I also alerted him to the fact that once I'd seen the order, that the return date was only the 29th of July, and I told him that I know the return date is the 29th of July. Not once did he tell me that that date had been a mistake, and that he was going to go to court on Monday to correct the date to the 29th of June. By chance, on the Monday, we had discovered that despite him agreeing to give me all notice, and because of the urgency of the matter, and because of the fact that I was based in Cape Town, we had agreed that all correspondence and pleadings would flow via email. He didn't notify me again, so again he was trying to without informing me, get that date changed as to when the bodies had to be reinterred.
Okay.
So, there's just such a lot of bad faith on the part
All right,
of
Mr.
the
Jansen,
ways.
we're going to leave it there, but thank you very much for taking the time to speak to us. That's Chief Mandla Mandela's lawyer. To explore the legalities of this matter, we're now on the line to Wits University Law Professor David Unterhalter. Very good morning to you, and thank you very much for speaking to us, Professor Unterhalter. Just listening to Mr. Jansen there, he talks about bad faith, but to begin with, he spoke about the lawyers plagiarizing themselves in the certificate that they submitted to the court. On the face of it, I understand that the complaint is still to be lodged and this matter assessed. What is your sense of what is at the heart of this complaint?
Well, I haven't seen the court papers or the complaint that is going to be made, but obviously to get a court to hear a matter urgently, there have to be grounds of urgency and they have to be set out in an affidavit. Now, it appears that certain things were said as to urgency, but particularly that Mr. Mandela is on life support and was in a vegetative state. Ultimately, it is clear that Mr. Mandela is in a very serious condition, and that was probably the ground upon which the court decided that the matter was urgent, because obviously his life is regrettably very much in the balance at the moment. And that's the substantial ground, one would imagine, upon which the court acted. Whether the fact that he was in a vegetative state or not was the key determinant, I'm somewhat doubtful about. But ultimately what will have to be looked at is whether there were claims made either by the litigant or by the attorneys knowing that what was being said was false. That will have to be examined to see whether those claims were exaggerated. But I'm not certain that the exaggeration, if there was an exaggeration, really takes away from the overall facts, which is that...
You were just saying now that you very much doubt that so-called exaggeration would have been the basis on which the decision would have been made in terms of the urgency of the matter. Why is that?
Well, for this reason, that ultimately the fact is that Mr. Mandela is in a very serious condition. It appears that he is on life support. And in those circumstances, one would imagine that the court would consider the matter urgent, whether or not Mr. Mandela is in a vegetative condition, which appears to be the matter in issue, which is said to be the exaggeration. And so I think substantially the court was satisfied that the matter was urgent because of the serious condition in which Mr. Mandela regrettably finds himself, and which is the official position, as we all understand it to be. That renders the matter urgent.
What would be the likelihood of a matter being heard urgently in court without the respondent being informed? And if that is the case, what would be the punitive measures that one would be allowed to take against somebody guilty of that?
Well, again, it's a necessary part of any court proceedings that usually one will have to inform the other side in a proper way that proceedings are going ahead, and there are special circumstances in which that can be waived, but usually the other side must be informed. If, again, a court is misled as to the state of affairs, as to whether the other side knows, then that can be a professional breach, but more particularly you can go back to court and say, well, the order has not been correctly obtained because we were misled, or the court was misled as to the true state of affairs. That can be done, but as I understand it, Mr. Mandla Mandela doesn't wish to change the order that was granted. He complains about the process, and these will be matters no doubt taken up by the respective law society that is involved. But these questions will need to be determined very much on the facts as to whether in fact the respondents didn't know, or when they did know, couldn't have done something about it, and
okay.
those are facts that will have to be determined.
Professor David Unterhalter, he's a professor of law at Wits University. Thank you.